All right, good afternoon, everybody. Welcome to the Martinez Law Legal Lounge. Thank you all so much for joining. Happy Monday. I hope you are all off to a very productive start to your day. My name is Kristen Martinez. I am the owner of Martinez Law, and I host these episodes every single week on Mondays to provide kind of an informal setting, a no-pressure forum for you to attend and ask your real estate-related questions. I know from speaking to real estate professionals in the community that you have questions a lot of times that you don't think maybe is worth an attorney's time or bothering an attorney for, or maybe it's not something that needs a full formal consultation. That's what these forums are for. So make sure to tune in every single Monday at 12 o'clock with your questions. I will be answering them live to you. With that being said, if you are joining us today, go ahead and leave us a comment below. Introduce yourself, say hello. I would love to acknowledge you. Also, if you have questions that you would like me to answer, you can go ahead and start putting those in the comments as well. I have a few short announcements that I want to go through, but if you want to go ahead and put your questions in the comments, I will be getting to those very, very shortly. Just a little bit about me. I have been practicing real estate law for the last 10 plus years here in the Tampa Bay area. In 2015, I founded Martinez Law, which was and still is a full-service real estate law firm. All we do is specialize in real estate law. We do not handle any other practice area. We do not provide title work or title services. All we do is give legal advice, represent clients, litigate disputes, all within the real estate realm. So we are your go-to experts for those types of questions and issues that you have, that you may have as they come up. One goal I had in creating the law firm was to educate the public and specifically those in the real estate community through my practice and through public speaking and presentations and things like that. And so these weekly Legal Lounge episodes are just one way that we are doing that. So please utilize it. Bring us your questions. I would be happy to answer all of them live. We actually have several questions that came in throughout the week through social media. So I will be starting with those questions. But of course, as you have questions, please put them in the comments and I will be sure to get to those. A couple of firm announcements I would like to quickly go through. We do have a YouTube channel where we repost all of our video content. So that includes these episodes. If you miss a week or if you see on a comment that there was a question addressed or a topic discussed that you are interested in, make sure to go to our YouTube channel and check out past episodes. We also post our other events as well as video content throughout the week. So make sure to check that out. Additionally, our July event for Get Real with Attorney Martinez will be on July 7th. We are going to be talking about neighbors that are driving you crazy. We're going to be addressing nuisance laws, trespassing laws, and easement issues and disputes. So be sure to register for that on Eventbrite. If you need the link, just go ahead and DM us, and we will be happy to get that over to you. Again, thank you all who are joining us today. Welcome to the Martinez Law Legal Lounge. I am here to answer your questions live, so please say hello in the comments. Please post your questions there, and I will be sure to answer them. I am going to go ahead and formally open it up for questions and answers, but I'm going to go ahead and start with some questions that were submitted to us throughout the week after last week's episode. If you attended last week's, you know that pretty early on in the episode, I lost my voice. I only got to address one question, so I am definitely going to make it up to you this week and make sure to get to all of those that were submitted to us after the fact. So the first question is, how far in advance should you get paperwork squared away before closing on a house with someone who is not your spouse? So there are always some additional items that we need to consider when you're purchasing property with a relative, a partner, a girlfriend, boyfriend, somebody who you are not legally married to. Because in Florida, there are certain rights and laws that apply between husband and wife, or between partners who are legally married, that do not apply to any other folks that are jointly owning property. And so there are some paperwork and some agreements that we need to get in place beforehand to make sure that both parties are protected. So as far as how far in advance, the sooner the better. We obviously need to have a property identified, ideally being under contract on a property, before we're going to go ahead and put together an agreement between the two owners as far as, who's responsible for the monthly expenses related to the property. That could be maintenance items, electric bill, mortgage payments, things like that. What happens if somebody wants to sell the property and the other person doesn't? When the property does sell, who is entitled to the proceeds, or are we splitting the proceeds 50-50? All of those things are extremely important to get in writing prior to purchasing any property with somebody other than your spouse, because while at the beginning things are all very amicable and nobody intends for anything to go wrong down the road, unexpected things happen. Life happens. And even if it is amicable, it is much better to have everybody on the same page, have a clear written document that shows what happens under what certain circumstances, so that there are no questions between either parties, and hopefully we can prevent any disputes from arising in the future, because it's all decided on the front end. So the bottom line takeaway here is, if you're purchasing property with somebody who is not your legal spouse, you are not legally married to, you need to enter into an agreement that details how the property is going to be managed, who's going to pay for what, and who is entitled to the proceeds, ideally prior to purchasing that property. Excellent question. Thank you so much for submitting that question to us. The next question, and before I get to the next question, I will just quickly remind you, make sure to check in, say hello in the comments, and post any questions that you have down in the comments. I will be answering all of those questions live for you. Okay, the second question that was submitted prior to today is, what is the benefits of buying property under a trust? So I think we need to differentiate here whether you are purchasing property as an investment, or whether you are purchasing property that you are going to live in as your primary residence. If you're purchasing property to live in as your primary residence, the Florida Homestead Protection will protect that property from creditors, things like that, so that if you were to get sued or you were to get in a car accident, your primary home cannot be taken to satisfy that sort of debt. Your mortgage is a different story, but all other debts and creditors would not be able to lien or foreclose on your primary residence for that reason. So if we're talking primary residence, the reasons to put it in a trust are less, but there are still some good reasons. If we are talking in contrast about an investment property, so a property that you're going to rent out, a property that you're going to let your family member live in, a property that you're going to buy, fix it up, and flip, no matter what your intentions are with it, if you're not going to live in it as your primary residence, it needs to be in some sort of entity, whether that be a trust or some other sort of type of corporate entity like an LLC. The reason for that is to protect your personal assets from any creditors that may attach to you. So if you own your property in your personal name and you get sued on a completely unrelated matter, that creditor at the end of that lawsuit, assuming they win, they become a judgment creditor, they have access to all assets that are held in your individual name, which would include your investment properties. So that is what we want to avoid. My personal recommendation would be to put your investment properties into a Florida land trust. I also utilize LLCs for my clients a lot, depending on what your specific goals are, will depend on what my recommendation is for you. I would love to discuss that with you. So if you would like to learn more about that or discuss your specific situation and have me make a recommendation, please feel free to call my office. I will go ahead and post in the comments our office number for you, but I would love to set up either in person or a phone meeting with you to talk more about those options. So the main benefit is going to be protecting your personal assets from that liability. Another reason, and I'm just going to touch on the big ones here for purposes of time today, but another reason would be to protect your identity. So when you purchase property in a Florida land trust, your identity, the person behind that Florida land trust, is anonymous. You are not identified in the public record anywhere. That is a huge benefit if you are purchasing investment properties, because as you grow your portfolio, you become more and more attractive to people who may want to sue you. So one thing that I do in my firm when a client comes to us and asks us to file a lawsuit on their behalf is we research the person they're asking us to sue to see if they have any assets, to see if it's worth my client's time and money to pursue this person. If I search your name and I see that you have a portfolio of 10 investment properties or more, you look very attractive to a lawyer that's looking to sue you. And we obviously want to avoid that. So the second big reason why I recommend Florida land trusts is to protect your identity, so that if you have, a tenant that's unhappy that may be considering suing you, or whatever the case may be, at least from a public record standpoint on paper, it appears that you have no assets. That's what we're going for there. Okay, as you have questions, I have a couple of more that were submitted to us throughout the week, but as you have questions, please go ahead and put those in the comments for us. Also, make sure you say hello to us in the comments. I would love to recognize you and personally thank you for attending today. So our next question is, what is the importance or difference in buying property as tenants in common versus joint tenants? So the primary difference here, and this is when, again, you are purchasing property with another person who is not you, who you are not legally married to. So when you do that, you have two options. Taking property as tenants in common means that each owner, let's assume there are two co-owners for purposes of this example. Each owner owns 50% of the property, and they can do whatever they want with that 50%. They can sell it, they can leave it to a relative in their will. When they pass, they can do whatever they want with that 50%. And it stays with them if they were to pass away. So when they pass, their 50% would go to their heirs or whoever they designate in their will. Conversely, if you purchase as joint tenants, that is going to come with what's called a right of survivorship. And that means basically that when one co-owner passes away, instead of that co-owner's 50% of the property passing to their heirs, it will automatically pass to the surviving co-owner. So if you own a piece of property with your cousin, let's say, and you pass away, while your cousin is still living, your cousin then, upon your death, owns 100% of the property, and your heirs will not take any of it. So as far as those are the differences as far as whether you should take property as tenants in common or joint tenants. That's just going to depend on your specific circumstances. So again, I would love to talk to you about those circumstances and when it makes sense to own as joint tenants with rights of survivorship or just tenants in common. But the big difference there is going to be what happens to the property when one co-owner passes away. Okay, and then the final question that we had submitted, and again, I will pause briefly to remind you to go ahead and post your questions in the comments. Charmaine, thank you for checking in. Very nice of you to join us. Thank you so much. Geraldine as well, thank you for submitting some questions in advance, and thank you for checking in with us as well. If either of you have some additional questions, please go ahead and put those in the comments, and I will be happy to answer them. The last question that we have is, can a non-realtor, a person who is not a licensed realtor, is there any way that they can list property on the MLS and receive an assignment fee from the seller when that property sells? And the question was kind of followed up with, and what if there was a contract to that effect, signed by all parties, signed by the seller saying, I agree to give this person an assignment fee if and when my property sells. From a legal or a contractual perspective, is that possible to do? Yes. Parties, for the most part, can agree in a contract to whatever they want to agree to. So there's nothing in that sense that would prevent that contract from being enforceable. However, there are laws and rules that govern licensing and specifically licensed realtors that would prohibit this. So even though in this example we are talking about an assignment fee versus a commission, when we get down to it, it really is going to be seen from a legal perspective as the same thing. So ethically, a person could not agree to sell property for a property owner in exchange for an assignment fee without that being unlicensed real estate activity. You would need to have a license to sell real estate in order to do something like that. So again, excellent question in this market. A lot of my clients are trying to be very creative in different ways that they can take advantage of the market, leverage the market, and I love all of those questions. They really keep me on my toes and help me to think creatively about how we can work things out to accomplish my clients' goals. So I love those questions. Thank you so much. Neil, thank you so much for joining us today and checking in. Daniel, thank you so much as well for checking in. Listing assignments is against Stellar's rules. I've actually had a conversation with them about this. Yes, so you would not be able to take an assignment fee for selling a property without having a real estate license. So again, thank you everyone that has checked in. Thank you for the questions. As you all have questions, please make sure to put them in the comments for me. We do have several minutes left before we will end for today, so I would love to take your questions. I had a couple of questions kind of from a couple of weeks ago that I previewed for this week. So unless I see any questions pop up in the comments, I will go ahead and address those. One thing that I am seeing a lot right now is new construction purchase contracts. So with this market, a lot of buyers are resorting to new construction because they simply can't compete in this seller's market, whether it's because they don't have a certain amount of cash to contribute toward a purchase or whatever the case may be. It's an extremely competitive market, and so new home builders are loving it. They're very busy and they're building a lot of homes right now. I get a lot of people calling my office asking whether I will review their new construction contract prior to them signing it, which is always an excellent idea. Yes, I'm biased, but you need your contracts reviewed before you sign them. The thing that I always tell clients, which I want to point out for you today when it comes to new construction contracts, is in general, aside from the market as it is today, but in general, builders are typically very unwilling to alter their contracts. Now, aside from negotiating purchase price and deposit amounts and upgrades, things like that, that's all negotiable. But as far as their standard contracts and what they have developed with their team of lawyers to include in this standard contract, they are typically very unwilling to change or negotiate any of that. So I always get the question, well, why should I have you review it? What is the point, basically, of having it reviewed? The point is, number one, my job is to review it and make sure that there is nothing in there that is going to put you as the buyer at risk. And if there is, that I'm educating you about that risk so that you can make an informed decision on how or if you want to proceed. My second job is to educate the client on what is in the contract. There are a lot of provisions and legalese in these contracts, more so than our standard Florida bar contracts, that even as attorneys, we have to make sure we're going through very carefully to make sure that we understand how those provisions work in practice. And so A lot of the litigation side of my practice, a lot of the lawsuits that I handle result from people signing contracts and they don't know what the contracts say. So they don't know, they're not intentionally violating the contract. They don't understand or realize the consequences of violating the contract. And so they do something that is a breach of that contract without really being intentional about it. And that results in a lot of disputes. And so a big part of my job is to go through that contract with the client in detail, making sure I'm addressing any questions that they have and making sure that I'm educating them on how this contract works, what happens if you do this, what happens if they do that, what happens if the home isn't done when they say it's supposed to be done. All of these nuances that will certainly come up throughout the new build process, I need to make sure the client understands on the front end and is comfortable signing an agreement that has those provisions in it. So that is a big part of my job. I will wrap this question up with just stating that in the current market, builders are even less willing to negotiate their standard form contracts. I actually last week had a builder tell me this contract is take it or leave it. No financing contingencies, no nothing. We have a long line of people waiting for us to build their homes, so your client can sign it or not. If not, we'll move on. Not ideal from a customer service standpoint, kind of off-putting for my client, but that's the reality of their market, the market that we're in today. So if you are interested in a new construction home, I absolutely recommend that you have that contract reviewed with an attorney so that you can make the most informed and best decision for you in whether to move forward or how to move forward. Jerry, thank you so much for your question. What is the expected turnaround time for a new construction contract review? Excellent question. Thank you for asking that. So the way that I set my calendar in the office is real estate, as you all know, is very time sensitive, very fast paced and fast moving. And so I make sure to leave time in my calendar every single day to account for either emergencies or very time sensitive items. So my turnaround time, we will typically quote 48 hours. However, if you call in and you say, I need this done by first thing tomorrow morning, I need to sign it by, close of business today, if my calendar will allow for it, I will make it happen. And usually the only time my calendar will not allow for it is if I'm physically in court for the entire day or something like that. So I know the fast pace of the industry and I have set myself up to be able to accommodate that. But just in general, if it's not any sort of more urgent than normal situation, we will quote 48-hour turnaround time for a new construction contract review, which means that I will have it reviewed and schedule a consultation with the client to go through that with them within that 48-hour time period. Awesome question. Thank you so much for attending and checking in with us. All right, last call for questions. This was a really great discussion. I truly appreciate everybody who has attended. I appreciate all of the questions. Thank you all for checking in. We will be here next week, same time, same place, Monday at 12 o'clock on Facebook Live. Please don't forget to like this video, share it with your network. As many people that can view this video and get educated on these different items, the better. It looks like we have one more question coming in from Charmaine. I will go ahead and address this one. We are obligated to submit all offers up until time of closing. It is important to have all necessary documents, addenda, etc., but sometimes a form is missing. Lately, I have seen agents having a list of documents they want with an offer and will state offers will not be presented without documentation. Is this a violation of our obligation? Excellent question. So we're talking about here when you're representing a seller, ethically as a realtor, you have an obligation to present all offers to the seller. The question here is, what happens if an incomplete offer comes in? What happens if we firmly state no offers will be presented unless all of this documentation accompanies your offer? If an incomplete offer comes in after that kind of disclaimer is stated, do I still ethically have to present that offer to my seller, to my client? My answer here is going to be yes. I don't think you risk any sort of disciplinary action if you do not present an offer, so long as your client has authorized you to put in that disclaimer and your client has instructed you, I don't want to see any offers unless it is complete with the contract and all the list of required documents that we have requested. If your client has given you that specific instruction, I don't think there's any issue with not submitting offers to your client. However, as a best practice, from a realtor standpoint, I would still recommend submitting them. I know in this market you are getting a ton of offers. You're probably getting many offers that are not complete, that do not comply with the instructions that you've set up on your listing. And I understand that that is time consuming for you and probably a little bit frustrating for you. But as a best practice, I would still present it, because at the end of the day, your goal is to get the best deal under contract for your client. So let's say an incomplete offer comes along and you present it to your client. You can say, hey, I know you told me not to present these. This one is incomplete. Here's what it's missing. But in case you wanted to take a look, I've enclosed it for you. I think that is a best practice, because if that offer has, some sort of unique aspect about it, or it's a unique situation that your seller is really interested in, even though it might be incomplete, that may result in a better deal for your client than another offer that may have complied with all of your instructions. So the takeaway here is, ethically, if you have the specific instruction from your client, I don't think it's necessary for you to present all offers, but as a best practice, I would recommend that you do. You're very welcome, Charmaine. Thank you so much for the question. Last call for questions before we end here. We will be back here next Monday at 12 o'clock for the Martinez Law Legal Lounge right here on Facebook Live. If you have any questions for us throughout the week, you can always send those to us by email. You can send those to us through any of our social media accounts. I will jot them down and make sure to address them for next Monday's Legal Lounge episode. As always, you can always also attend and put those comments into those questions, into the comment section, and I will be sure to answer those live for you. If you have any other questions about anything that I have addressed today, please feel free to call our office to schedule a consultation. I would love to talk with you in more detail and give your case the time and attention that it deserves through a formal consultation. So please do that. Otherwise, thank you again, and we will see you next Monday.